It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And today we are going to look at some very serious updates to the UFC antitrust cases. We're going to talk about Zuffa Boxing's debut, and we're going to talk about the UFC's debut on Paramount Plus. But if you want access to all of those things, you're definitely going to need to subscribe with your money, because half of this will be behind a paywall. Now, before we get into all of that, John, how are you? Because I am feeling the polar winter over here.
Yeah, the whole country is getting a glimpse of what we get up here. Obviously, you're as cold as it is there. It's nothing like the Arctic tundra that it is here. Even though it's warmed up, it was a balmy, I think a high of 6 degrees today is a high. Balmy weather. No, 3 degrees I think was the high today. So that is warm compared to the last few days we've had here. And so, you know, I got to go outside today. I've been outside every day, but today we went for an extended trip to go get breakfast, watch some football, getting ready to go to, flying back to LA, taking my mom with me to the warm weather for a couple weeks. And then I got to come back to the tundra before I hand her off to my brothers.
Oh my goodness. Well, I'm glad Mom will get to have some better weather, because my goodness, this weather is... I don't like the ice, okay? I do not. I watched a clip of a weatherman in Wichita Falls, Texas. I watched a clip of him ice skate from his apartment to the news station. Ice skate. And they had obviously a cameraman film the whole thing, but he literally was ice skating on the streets. That is crazy for Texas.
I'm sure it is. Yeah, we could. I don't think I could do that on the streets because we're very good at salting them. But yeah, I don't think we have to worry about ice skating on any lake or pond in the region. It is frozen solid. They're all safe. You can drive on all of them at this point. My
goodness. Well, in any event, I'm not a fan of the ice. And, you know, I'm from New York, but we don't get the ice storms. We get snowstorms. You know, you get snowed in. You don't really get ice storms because down here in Texas, we just don't get that kind of weather, and we're not built for it. The whole place isn't built for it. The infrastructure isn't built for it. So we've had lots and lots of multi-car pileups already too.
Oh yeah. That's whenever there's snow and ice in a place that isn't used to it, there's problems. But you know, not being a fan of ice right now seems to be the general opinion of the Twin Cities. So you are in company with us here. We are not fans of ice right now.
And I, you know what? I am of a mutual mind with you in that regard as well. But anyways, I guess we should get started because we have a lot of ground to cover. Now, we had some serious updates to the antitrust cases over the last few days. What were they?
Well, this is pretty important stuff, so obviously no one's going to cover it except for us. And, you know, I will give a shout out to the MMA Draw. We'll surely cover it with Zach Arnold and maybe a few other people, but generally, this will go under the radar of MMA media because they do not care to cover this story. But if you're a fighter, well, if you're a fan, first of all, you might find this interesting. But if you're a fighter, especially if you're a fighter that fought in the UFC during the Johnson class period, which is from July 1st, 2017, and you are hopeful that they can potentially get a class certification for that group and get a settlement like the Lee class or go to trial and win, any of those things. This is pretty important what's going on right now, so you might want to pay attention.
That would be July 2017 until now?
Yep, until now. So everybody who's fought the UFC from that date until now, they are in that class potentially if they grant class certification. And so the important thing is, on January 6th, we go back to January 6th of this year, we talked about this. The district court, Judge Boulware's court, issued an oral discovery order that compelled the defendants to produce privileged attorney-client communications. including past and future discussions about litigation holds. And so that was for an in-camera review. So, right, that was for a hearing, a status hearing for January 26th, coming up next week. That was supposed to be handed over by. And it also required that UFC executives Dana White and Tracy Long to testify in these matters on February 4th and 5th of next week, I guess, right? Citing a potential spoliation of evidence. So in response, this is the stuff that's happened now over the last, week, basically, less than a week. On January 20th, the defendants filed a motion to stay. We talked about that in the last episode. The order in the District Federal Court of Vegas with Boulware, same court as Boulware, arguing the irreparable harm from disclosing of core privileged legal strategy materials, likely success in appeal, minimum prejudice to plaintiffs, and public interest in protecting attorney-client privileges. The stay they're asking for would pause enforcement pending Ninth Circuit review, because they wanted a stay of the case, in other words, in Vegas, in the district court, where Boulware's rules, until Ninth Circuit could review. In support of it, they wrote a petition for writ of mandamus. What that is basically on command. It's an order, a petition to a higher court saying you have to please command this lower court to do this. And so they sent that to the Ninth Circuit, seeking to vacate the order as clear error, the order being his compelling the defendants to produce privileged material. It claimed the ruling improperly pierces attorney-client privileges without adequate justification, authorizes overly broad discovery into legal strategy, and violates the First Amendment by mandating disclosure of future communications, right? So potentially chilling candid legal advice. Okay, so notably, the mandamus petition includes a section arguing that have granted that the case that the case be remanded and reassignment to a different district judge is warranted. So they were asking in that mandamus not only for a stay, not only for review by the Ninth Circuit, but also to reassign Judge Boulware. The defendants contended that the original judge's intrusion into privileged areas would create an ongoing chilling effect on attorney-client communications. So these aims, the actions they took, I should say, they aimed to block immediate compliance and preserve confidentiality. So that's what happened the 20th. So 2 Ninth Circuit filings then were filed just a few days later, January 22nd, January 23rd. And in it, there was a Circuit Rule 27.3 certificate that certifies the urgency for administrative stay and a full pending mandamus. And it argued for relief as needed by January 23rd to avert irreparable harm from disclosing privileged material for that January 26th deadline. And disclosure would impair defense preparation and chill ongoing legal counsel-client dialogue. And they cited a bunch of cases for that. And then it explains in the timings that it awaits a promised written order that, let me rephrase that the filed mandamus and district stay on this January 20, it notified all parties, right, that explains the timing as they waited the promised order that hasn't appeared yet from the Ninth Circuit. So I hope that made sense. And then they also filed with that an emergency motion for administrative stay and stay pending appeal, which seeks to halt the required production of the vast privileged documents and halt the testimony from Dana White and Tracy Long. And then this background recaps overlapping antitrust suits, just went over a ton of material. And so those were the filings leading up to the end of last week. And then on Friday, the Ninth Circuit ordered granting an administrative temporary stay of the district court's discovery that the Judge Boulware ordered on January 6th that was going to happen on January 26th. And then there's the panel of judges. I believe the names are, if I look through it, Judge Silverman, Pez, and Thomas. They said they notified them that they received the defendant's emergency motion for a stay pending the resolution of their mandamus petition, and the court temporarily stays enforcement of the order, which required production of the privileged client communications related to the January 26th and the January 26th deadline that Judge Boulware put in, plus testimony from Dana White and Tracy Long on February 4th and 5th. So there goes that hearing that we've been talking about for a while. But it emphasized, this is the important thing, it emphasized this administrative stay preserves the status quo only until the full stay motion can be decided on the merits and expresses no underlying view of the merits. And the order directs the real parties, that's Cajun, the plaintiffs, Cajun Johnson suit, to file an answer to the mandamus petition in response by 5 p.m. on January 26th, that the district court Judge Boulware here, he may optionally, if he decides, respond as well. And then a copy of that was sent to the district court and Judge Boulware, and that's why it was posted on Pacer for me to see. So that's the material that we had filed over the last few days.
Back to the part where the court issued a stay.
Yes.
Explain what that means in layman's terms.
Well, what that means is that the plaintiffs, the defendants actually in this case, UFC asked the court to basically halt proceedings. They put a motion in that they do not want to hand over their material to the judge to peruse. Mm-hmm. And so they filed for several motions, as we've seen, including an emergent mandamus to order Judge Boulware to stop this, and then an emergency petition. Basically, we want the case to hold for now until you can review our motions, arguing that we should not have to hand this material over to the judge, to the plaintiffs, that this stuff is attorney-client privilege. So for the Ninth Circuit, after the defendants, Zuffa did this, what the Ninth Circuit did is they upheld a temporary pause, basically halting the necessity for the defendants to hand that material over on January 26th and likely pausing the testimony hearing that they had planned for February 4th and 5th. As the Ninth Circuit made it clear, though, this is a temporary pause. They are not ruling on the case at all. This is not a ruling in favor of the defendants or the plaintiffs. This is a temporary pause so they can actually hear the complaint, look at it, and make a judgment. And they are given other parties involved a chance to respond as well. So that's where we're at right now, a temporary pause. Now that could be extended into a longer pause, whatever else might happen. They might decide not to look at it, but that's where we're currently at, a temporary pause in the production of discovery and testimony that the defendants were requested by the judge to hand over.
Okay, I have an off question here that's I'm going off script for a second. Do we know if by any chance there are any campaign contributions or anything like that to any of the judges on the Ninth Circuit?
That I don't know.
Okay.
I do not. Well, I mean, federal judges don't usually have campaign donations because federal judges, they are appointed.
Any kind of link. I'm basically looking for a link.
The link would be that they are appointed by, you would see, a Republican or Democrat. Mm-hmm. That's generally how people weigh how they might rule, but that doesn't always add up. A lot of judges rule differently than what you'd assume. But I'm not certain. I think the judges on that list I looked at before, I think they're mostly appointed by Democrats, the three guys there. But I know nothing about, who's, what their political affiliations are.
Okay. All right. Does the UFC have a strong argument with these filings?
Well, that's another good question. And I would say, this is personal opinion. No, they seem very desperate in these filings. You could tell that they were maybe thrown together at the last second because they were nervous about this January 26th deadline. Now, in spoliation cases, which are destruction or loss of evidence, the spoliating party, right, they bear a greater burden to identify and provide alternate sources for lost material, particularly when the spoliation is considered like intentional or bad faith or grossly negligent. And that's the question about the spoliation we have here at the UFC, because they were told to preserve this. It's just the material is missing, like Dana White's phone and text. So it looks like, is this intentional? This is not like I put the material, we had a bunch of it, I put it in the basement and we had a flood. something like that, like it was an act of God. They were told to preserve it, and it's lost. And it looks like it might be important material for the case. And so often in these cases too, in electronically stored cases, the one party will say that, sanctions are not necessary against us because the lost data can be replaced through additional discovery. And so the courts can shift the burden to mitigate. But here, in the filings for a lot of them, the defendants, UFC, is basically arguing it's the plaintiff's responsibility to find this material. Where again, as I noted, is that it's on the party that had the issue with the spoilage. They're supposed to have the greater burden of producing it, and they seem to be leaving it completely up to the plaintiffs to find another source. And then you have all these like managers and stuff that are not supplying text messages and stuff that could fill the blank. So that's one part I think is kind of weak about the UFC's defense. The other one is they cite multiple cases, and Fred Garvin on Twitter might like this. He brought this up. They cited Ecuador versus McKay. And that case they cited, it's a case that says that work product protections for testifying experts, it holds that opinion work products, in other words, where you have an expert that's kind of like a attorney-client privilege type work, and they give an opinion, that should remain virtually undiscoverable. That's material you don't have to share. But what doesn't seem to work in the UFC's favor here is the Ninth Circuit's ruling on that case stressed that it was not a blanket immunity for all expert-related materials. And it should be noted, Dana White, Tracy Long, are they expert witnesses? Not really. They're executives. They're fact witnesses. They're people in the company who were named ahead of time. So these are not, expert opinions. These are people that have important information about the company. So it doesn't quite apply to them. And also as the defendants, they cite Mackey, it's narrowly for virtually undiscoverable footnotes that shield mental impressions and stuff by attorneys. And here though, what also helps the plaintiff's cause is that the stuff they're asking about for client attorney privilege, it's some of the material is that they haven't handed any material over. I mean, they've handed some, but huge gaps of material is missing. So it's like, well, you are allowed to narrowly do it, but these are vast breadths of material that has not been handed over. So it seems pretty, I don't want to say, I guess I will say it seems pretty weak to argue that, right? That you can make the claim that this stuff's privileged when this case you cite specifically says it's supposed to be used narrowly. And like for Dana White, we're missing 6.5 years of material. That doesn't seem narrow right there. And overall, too, the defendants, they frame the order as unprecedented overreach. But if you look at the prior spoliation history, and Mackey's as well as their pro-disclosure stance provided the district court, that it provides grounds for scrutiny, and that potentially makes the mandamus relief harder to obtain. So when I look at that, I don't think the UFC has much of a case. Now, there's a caveat there, is we are living in a Trump world, right? And the courts operate in a different manner than they did a few years ago. And so is it possible they're expecting a friendly court somewhere to look at it? And a friendly court would be the Ninth Circuit, but it doesn't look like these justices would be particularly friendly. Are they hoping it gets to the Supreme Court? That's a possibility too, but I'm not, the Supreme Court hasn't proven itself to be 100% of support of a people just because they're Trump friends and allies, right? So right now you have to look at this and say, just on basic legal history, the way these things were considered in the past, this seems like a weak case, but we are in uncharted waters recently, I think, as everybody's noticed in the news.
What is the risk for the UFC if they don't get the courts to rule in their favor here?
Okay, so we've gone through a lot of stuff, and I'm sure people head might be spinning because there's a lot of legal jargon or legalese I kind of mentioned there. But the thing is, what makes this important to talk about is that the UFC could be in serious trouble here. And I'm not trying to be one of those, one of my pet peeves is the MMA, YouTube channel guys. They're like, I'm sure everybody's seen them like, oh, the UFC's in trouble this time. This is the end for them. And it's, really it's nothing. We've talked about court case on before, like it's a minor thing or whatever, and everybody blows it out of water. But this time it potentially could, because you got to remember this. Okay, if they don't have this material, if first of all the Ninth Court of Appeals turns down their petitions, which seems likely, seems the statistical odds you'd bet on that, and it goes back to Judge Boulware. And he has to make rulings. He has several cases in front of him. He has the Johnson v. Zuffa case in front of him. He has the Serkinov v. Zuffa case in front of him, and he has the Davis v. Davis v. Zuffa case in front of him. All of them share the same evidence. Now, right now, they're focused mostly, they say it's for Johnson v. Zuffa, but really they're focused on Serkinov v. Zuffa for the arbitration agreements. And they're doing searches into the, discovery searches for material about the process by which they wrote up their contracts and how they were determined how fighters signed these contracts with arbitration agreements. Now, there's several rules under Nevada law. I want to first point under the FAA, the Federal Arbitration Act, the federal courts supersede anything on arbitration agreements. So that's why a lot of people thought this case with the arbitration agreement component would be dead in the water, because that supersedes the state level. But there's a few carve-outs. And under Nevada law, there's an unconscionability ground. And since these contracts were signed in Nevada, that there's a possibility that if you look through it and see that the contracts are adhesive due to the UFC's monopsony power, and they're substantive, that the clauses are completely one-sided, okay, then the judge can rule that they're unenforceable. And so the judge needs to gather material to make that determination. And I think it's pretty clear the contracts were one-sided, because the fighters really got nothing. At least it doesn't seem like they got anything in exchange for, hey, signing all your rights away, signing your ability to take part in a class action. And so he has to look into were these contracts of adhesion, and the UFC used their monopsony power to force them on the fighters. So again, we need discovery. The negotiations that we saw before, the type of negotiations we saw revealed in the Lee case, that's all missing right now. So what happens if the UFC can't produce it? They said it's destroyed, it's lost. Well, then the judge basically has to take an adverse inference, right? He has to say that, it may not be required, but he has to infer that the destroyed or lost evidence would have been unfavorable to the defendant, UFC Zuffa, and supportive of the plaintiff's claims. And so that makes it much more likely, if you look at all that material missing, every time there's a question that could be answered by some evidence that they don't have because it was destroyed, the judge goes, well, I'm going to say it was unfavorable to the defendants, UFC, that in that material was something that showed they did this wrong, and favorable to the plaintiffs, it shows that their case is stronger. Then it's very likely for the first case, Serkinov, that's an order, a motion, so he only has to issue an order. He himself will say, I rule in favor of Serkinov. These arbitration agreements are unenforceable. And so every fighter that signed those arbitration agreements and class action waivers, they are now back in the Johnson suit. So just like that, the arbitration agreements, class action waivers are gone. And then we move on to the next case, Davis v. Zuffa. And if Davis can stay on the case, if the judge continues to say he has standing, well, that's not a trial. That's not a jury trial. That's a bench trial. So again, the judge will have to make a determination. A lot of the evidence, again, it seems to be missing. So he will have to have an adverse inference on it. And so when he issues his bench trial decision, he might very well say, I have to decide in favor of Davis because there is no evidence. The evidence that would support the defendants does not exist anymore. And so I have to take an adverse inference. And so Davis wins, and injunctive relief is ordered. And then we move on to the Johnson case at that point. And Johnson case is a jury trial, but when the case goes to trial, the judge is going to have to tell all the jury members that, I'm not deciding this case, you are, but you have to take an adverse inference that you should infer, that you can infer, I should say, that any destroyed or lost evidence would be unfavorable to the UFC and supportive of the Johnson and the other fighters. And that makes it much more dangerous to go into a jury trial because now the jury is already taking a position against you. So that's what makes this so dangerous for the UFC.
Why would they lose all that material and the spoliation?
Well, that's the $1 million question. Because we set it up now, because they lost that material, it seems very likely that unless they win one of these what seem to be Hail Mary suits, right? It seems very likely the judge is going to rule in their favor. So why would they lose it? What could possibly have caused that to disappear? We know it's not like they just forgot, didn't know they need to save it. This material has been ordered to be preserved since the Lee class was filed. And so you have to ponder, like, why wouldn't you present it if this is going to completely derail this case, as I've just said, is you just hand it over the judge and the jury and everything, an adverse inference on everything. And so I only have there's a couple theories. I can only make theories. And I guess one is, I think Zach Arnold brought this up and it seems logical. There are other lawsuits out there. There's the Icon lawsuit concerning the WWE merger. There's a lawsuit concerning Endeavor going out there. Maybe there's some material in there that would be bad to get out and damage them in that other suit. And they decided that because Dana White talks a lot, let's just delete all of his material, not risk it, because if it comes out in discovery for the Johnson v. Zuffa case, it's going to be entered into the cases for those other lawsuits, and we could lose that, and that could be billions and billions of dollars. So it's worth just taking the risk in this one case than these other cases. That's a possibility, but it seems a little odd to me that Dana White is the one being centered on this. Now, the other possibility, I guess, is if you remember Dana White was in a blackmail scam. Remember that scheme? Remember that?
Yep.
That case with the FBI, where he supposedly flew a stripper that he paid in coins down to Brazil. That sounds a little bit like a Mann Act violation. Perhaps Dana White, that, and these deleted material comes out after the verdict in that case. That case was decided. Perhaps Dana White decided just to delete everything, set up his all the stuff to delete, not save, because of that case. That's another possibility, that he was freaked out by it and doesn't want any of his material getting out. But right now we can only guess. But I mean, it seems almost insane to me that not one of their attorneys basically reminded the Zuffa figures, you have to save everything, because now we're in this position where they are filing basically Hail Mary prayers, like, please, Ninth Circuit, come and save our ass.
So what happens next? Is there any risk that the judge will be reassigned?
That again, seems unlikely on multiple fronts. First of all, the mandamus, that's an extraordinary remedy. And I looked up stats, and the Ninth Circuit only approves about less than 1 in 10 of them. So it's very rarely works. And the type of cases usually are different than this. So it probably even seems less likely that it'll work here. But I mean, maybe they'll grant part of it, but I can't see the full petition being applied. Now, the reassignment, that's also just an extraordinary remedy, right? That's very rare. And that seems extremely unlikely too, because there's nothing in the procedures by that Boulware that seems he's been acting with malice. I mean, I know they try to bring up he's an old classmate of Dana White, but it doesn't seem like he's been operating with malice. It doesn't seem like gross negligence on his part. Nothing like that would make it obvious that he could be replaced. So that seems incredibly unlikely as well. So, I mean, there is a chance the Ninth Circuit grants us, but my guess would be it doesn't. I guess so. We will wait and see if they do. But what happens in the immediate future is we wait for, that's more the few months down the road probably, and then the whole case might just they might have to settle. Who knows what's going to happen? Because again, if the court grants Boulware to do what he's been asking, the court says he's right, UFC is really, really fucked. So we got to remember that part. But what happens in the immediate future is, I guess that the plaintiffs, they have a chance to file their answer to this petition, and they can respond to the emergency motion by 5 p.m. on January 26th. The defendants may file a reply the next day by 5 p.m. And we'll have to see if Judge Boulware optionally responds. He's allowed to. He can also ignore it if he wants to, and just let the Ninth Circuit, just let his stuff stand on its own. The other thing we have to know is that I am not going to Vegas next week, so I can cancel my trip. I don't think there's any chance that it will happen because the temporary leave is blocking that testimony. So there goes the. Probably the one time we might see actual media members at the hearing is because the spectacle of Dana White being there. So we're not going to have that. But, we will wait and see. I guess we will see on Tuesday or Wednesday, I should say, if there's some filings. And then we should know sometime after that what the Ninth Circuit's decision is. And the case, I don't want to be dramatic, but I can't help it. In many ways, I think the UFC's standing in this case, their ability to defend themselves, the ability to win is all riding on what happens with the Ninth Circuit because of that spoilage, they have really positioned themselves in a terrible spot. And also on top of it, it makes it harder to appeal the decisions by the judge, right? So if the Judge Boulware decides against them, that you appeal the decision the judge makes, it's going to go to the Ninth Court on his order, let's say to grant circuit, if he does grant circuit off the arbitration agreement. Well, they're just going to go, how can we overrule him? You don't have any, but you lost all your material. He's ruling on that. So it really puts the UFC in a bind. I guess the one thing that could hurt the plaintiffs in this case is that if some of the fighters are ruled to not have standing, and then that gets to the question is, will other fighters step forward if that happens? If Davis is ruled not to have standing because he's part of the league class, will another fighter that has standing step in to take his position? Because it would be something if the Ninth Circuit did not agree to this petition by the UFC, but the Judge Boulware did rule in favor of them on position of standing for Davis. And so the UFC in many ways would be on the ropes, and yet they couldn't be finished because no fighter was willing to step forward and take that spot.
Good Lord. All right, so that's going to bring us to our next topic. Zuffa boxing. So we're going to just stick a pin in the court stuff because, the 26th is, we're recording on the 25th, on the night of the 25th. The 26th is tomorrow, which, all our listeners, that's today. So we'll put a pin in it and we'll revisit this when we record again Thursday night. So for all of you out there listening, don't worry. We will be updating you with our very next show. Now, moving on, Zuffa Boxing held its very first event on Friday. What did you think of it?
Well, I got to qualify my review here because it was incredibly cold here, and my screen was incredibly pixelated at times, and I was also very distracted by other stuff. So some of the stuff I just missed, where I had to wait for the internet come back on. And we can attest to this. We had conversations where my internet just apparently, who knew that the internet can't survive 20 below weather? Who knew that? But so I lost signal at time. But production wise, I will say, with regards to the cameras and the lighting, I thought that seemed mostly very good, right? The fights that I saw, I missed a lot of the fights that I kind of wanted to see. I really wanted to see Troy Nash. I'll be honest, mostly because of the name. But I wanted to see him fight and a few other guys that I didn't get a chance to see. So, I can't say that I thought the fights that I saw were particularly great. Not that they were bad, but not particularly great. So the main event, Kalen Walsh versus Carlos Ocampo, it was all right, but it wasn't like spectacular. I missed some of the best fights apparently. So the fights weren't that great. I did not like the uniforms, even though they're expected. I thought the look was lame with that. Kind of just robs boxing of its charm. Regarding the commentary, especially Max Kellerman, I don't know if you saw I know you saw Al Bernstein's tweet on this, that he's been announcing boxing for 41 years. And then he said, I have seldom said anything on the air about the promotional company on the card, even while sometimes doing pay-per-view fights in which I was hired by the promoter. And so he was kind of amazed at how much, I guess, glazing, as the kids say, Max Kellerman was doing. And I don't, as you know, I don't listen to the commentary usually on the fights. I turn a mute, but I had it on a little bit, and holy fuck, that was terrible. I'm like, what happened to that guy? So I generally thought, production wise, it looked good. Presentation was good. For the type of fight card it was, I thought it was not bad caliber of fighters for the type of fight card it was, but it wasn't like, this is not Saturday night boxing on HBO type caliber fighting. And then the TKO touches that they brought in, the brand stuff, the taking away the uniforms and the Max Kellerman glazing, that shit I could really do without.
Were you surprised that the very first event saw a boxer begging on TV? This was televised and everything. Saw him begging for a bonus because he can't make his ends meet.
No, I actually saw this part. This was the Hammer Hands guy, Rodriguez.
Yes.
And I don't think he was asking for a bonus, even though they had bonuses on this, because he was asking for a quick turnaround. Remember, he was saying, he did say, my family needs to eat, Dana, but he said, I want to be back in the PI on Monday. Give me a fight next month. So, it was not like the begging we see in UFC for asking for for a bonus. But I'm sure we're going to see that. I'm sure that will start popping up. But he was asking for a quick turnaround. But that's not surprising. Most fighters at that level, the $50,000 bonuses, which they did pay out to, I can't remember who got, Merriweather got it, I heard. And who's the other guy that got it? I'm not sure. I think it was the Hammer. Hammerhand's got a bonus, didn't he?
Well, I'm pretty sure at the very beginning of what he said wasn't that worth a bonus?
Oh, he might have. I might have missed it.
That was the very, very first thing he said. Then he talked about a quick turnaround, but he did mention a bonus. The first thing I noticed was Mookie Alexander, who barely posts about boxing anymore. He made a post that, LOL, this is turned into the UFC on their very first show. And,
it's unbecoming, but it's not surprising. I think the average purse was about 20,000 for these guys on the card, I'm never surprised. 50,000 is a lot of money for prelim undercard type fighters, and it's a good bonus for them. And I'm not surprising. It just, in some ways, I think what gets me is people focus on that. And it's understandable they focus on it because the UFC and Zuffa, the TKO, is just a massive company making so much money. It seems ridiculous that these guys, all seems unbecoming that they have to bag.
Yeah.
But I'm sure my position. A lot of these fighters are, they are replaceable, as bad as that sound. And it's the part that gets me is that you get to the guys that are some sort of rating or title and stuff, and they are not making as much as I think they bring into the organization. So I'm not surprised. It just does look bad, though.
What did you think about the media's coverage of the event?
Well, it probably got a lot more coverage than it should have. Honestly, right? The level of boxing here was kind of like ring. Remember the ring events that were happening right before the COVID killed them? Those were good cards. In fact, those are probably better cards than this in some ways, because I thought they were in some ways better matched. But this is not a bad card. It's not a bad, like a generally weekly type show, fight night, or Showtime after not Showtime after boxing, Showmax or Showbox, I should say, and HBO After Dark, that caliber of type show. it's not bad in that sense. But so if anybody else was doing a show like this, I don't think it would get much attention. In fact, we know a lot of DAZN events are like this to get no attention, but because it kind of shows you the brand power that TKO has and the fact that it's on Paramount. So it got a lot more coverage than it probably deserved. But I'm not surprised by it because one, everybody's intrigued by what TKO is going to do, Zuffa Boxing. And, Dana White and them have promised big things and people expect big things besides fights like cards like this. This is their apex. It's at the apex. This is their apex like cards. People expect something in addition to this down the line because of, otherwise what's the point of doing this big venture? And I'm pretty sure they're going to have bigger stuff down the line, but they do benefit because of the TKO brand and everything, bringing a lot more attention than it probably deserved.
What did you make of the reports that Alexander Usyk is in talks with Zuffa Boxing?
I'm not surprised. I don't know if he will sign with them, but I wouldn't be surprised at all if he did, because it's kind of what we've talked about a long time. What their plan probably is they're going to have these events that we saw with the headline by the Callum Walshes and have the Hammerhands and Merriweather and Troy Nash and all these guys on it that are steps below, that are ring event kind of potentially prospects, some not, but just journeyman, fringe rank guys, whatever. That they're going to have those events is, kind of filling out the roster and cards, and they can build from those. And then they'll sign a select few bigger name fighters. And I think the ones that they might go for are the guys that have the ring title, because then they can just crown them the ring champion. Jai Opete right now is one guy like that. I'm sure we'll get into what his belt situation is, but he can be cleared to the ring. They went for Bam Rodriguez. They tried to get. Usyk has the ring title. Guys like that make sense. Them and a few challengers, and you put some big fights on, and then eventually you promote the guys from the undercard to go fight them. So that kind of fits. We talked about this as being kind of their business plan, to have a select small group at the top and build a bigger roster at the bottom, and eventually they'll find a place where they'll meet. And at that point, they can cut everybody else out.
You mentioned Bam Rodriguez. I'm going to go off script again here, just really briefly. Were you surprised that Eddie Hearn was able to match?
No, not really, because I think one is, Zuffa Boxing. They are trying to do this somewhat affordable. The big, well, I guess I should be somewhat surprised in that the Saudis, Turkey, would be the one putting out the money for Bam, and maybe he really wanted him. But at the same time, it's not hard to notice that a lot of fights that the Saudis used to be putting on seem to be moving away from Riyadh season. Mm-hmm. And a lot of talk that the Saudis might not be willing to spend as much as they had in the past, and that seems very plausible. I mean, the fantasy a lot of fans had is that the Saudis have unlimited amount of money. They had tons of money and they're willing to spend it. But eventually, someone's going to step forward and say, we can't keep spending this money. There are smart people running their sovereign fund over there. It's not an unlimited blank check. I'm sure they let these, guys like Turki El Sheikh run for a while, but eventually it's like, we need to get a return on investment. And I think that's why TKO came in. They're trying to get something out of this instead of just spending money over and over again and seeing very little on their ROI. And so the Bam, I'm not really surprised, because I think there was some limit to how much they're willing to pay him. And also, Matchroom has put a lot of effort into kind of building him up, and I think they have a lot of plans for him. So it makes sense also they'll match him. Now the question is, there's no matching right in the future after this contract extension. After this is done, I think his next one has no matching right. And so the question becomes down the line when he comes up to be a free agent again, what position will Matchroom be to offer him a better deal than potentially what Zuffa Boxing could offer him? Then we'll kind of see what will the market be like at that time. And so will Matchroom have a stable spot that generates enough revenue that they can compete, or will they be struggling and Zuffa Boxing have grown to the point where they will be able to outspend for select fighters, in the beginning at least, select fighters spend as much as boxers expect to make those guys, and will they do that in this case? That'll be the interesting question.
Bam's kind of special. I think he's worth putting some money in.
he is special, but there is a question about, that weight class generally does not generate the revenue. Although, it should be noted, Hank Davis was in a weight class, and to a lesser degree, Lomachenko, Mayweather and Pacquiao migrated out of that weight class to make more money. But those guys were small enough and kind of introduced, especially Tank, that there's a lot of money you can make at that. And now Bam has potential if he could, a year or two move up. His timing's going to be hard. If he wants to spring up, maybe he can get in a way. And that would be a massive fight. But I love watching Bam. I mean, there's also a fact too. It's sometimes, you can't shoot everybody. That's some MMA fans often say, oh, he doesn't sell pay-per-views. He's not Conor, doesn't sell a million. Like they set an unrealistic level. People can be stars and valuable members to your roster and valuable fighters for a promoter without selling massive pay-per-views and gates and stuff. And I think Bam, even a guy like him, if he can't turn into a huge money generator like the guys in the higher weight class, he's still, I think, pretty valuable for what he could generate.
I know he's huge here in Texas. Absolutely enormous here in Texas. Everybody loves him.
Well, then look at that. That's good enough. Texas. Yeah, I don't know if you know this, but Texas is not a small state.
It's not, and I'm not trying to say anything other than I've noticed that he's really big here. So, anyways, what did you think about Dana White saying that Joe Patea will be allowed to unify titles after saying that they would not work with other promoters or with the sanctioning organizations?
Well, it's obviously hypocritical, right? But but Dana White's often been hypocritical. But it's not surprising, and it doesn't interfere with their plans. It doesn't. We've talked about a long time what we think they're going to plan to do, and the fact that they're going to work with other promoters, and the fact that they're going to let him unify them.
To access the bonus content of this episode, you must be a paid subscriber. To do that, go to heynottheface.substack.com and subscribe today.
Ow! Ow! Not the face! Ooh! Okay, the face!